Welcome back, everybody, to Senate Economic Development, Housing and General Affairs. We are going to be hopefully discussing, looking at the new language that CAM has worked on, and we're looking at H106, enact relating to selling real property within a FEMA mapped flood hazard area. So CAM, would you be kind enough to take us through the changes?
Yes. For the record, Cameron Wood, Office of Legislative Counsel. Okay, so what you should have in front of you is, and I'm going to share my screen and walk you through. Let's do that first. Okay, so H106, this is drafted as a committee amendment, a strike-all amendment proposal for H106. What we have is section 1. There are findings. I'm going to come back to the findings. So I'm going to skip to the language first, which is going to be on section 2, page 2. So as you can see, what I've done is I've struck subdivision 1 and 2. And instead I've inserted that the seller shall provide the buyer with a physical or electronic copy of the official flood insurance rate map as published by the Federal Emergency Management Agency.
It's called the rate map?
Mm-hmm.
Interesting.
Or notice that a flood insurance rate map is unavailable, effective for the community in which the real property is located. You would then keep the requirement that the seller notify the buyer whether there was flood damage while the seller possessed the property, and whether the seller maintains flood insurance on the real property. There was previous language from this committee or from the Senate that was about whether federal law requires maintenance of flood insurance. I kind of went back and forth whether to just keep whether the seller maintains flood insurance or whether there's a requirement. And I thought it best to just keep whether the seller maintains flood insurance. Presumably, if there's a requirement, then they maintain it, and they may maintain it if there isn't a requirement. So I just thought it probably best to keep that. There's the technical amendments in subsection C that I proposed and we discussed last time. I just think it reads better that way. And then I've removed what was D2, effective date October 1, 2025. I think there was discussion about September 1. You can change that to September 1 if you want. You know, October 1's a fiscal year.
October 1 was what Peter had requested.
I think it was September 1,
yeah.
but I
No,
moved
I
it
have
to
10-1,
October 1. That's a
He's
fiscal
right here.
year, but it's, you know, you can change it to what you would like there. Okay, so I'm going to move us back up to section 1.
So, okay.
Findings. And I'm going to pause here for a second for a few reasons. I just want to make the statement to you all. If the bill is being applied prospectively only, I don't think you need a finding section. Our office is cautious in doing findings because we cannot attest to the accuracy of the statements that you all would like to make in a finding section. And so I'm just identifying from our office's perspective, we typically don't do findings unless there are very specific reasons to.
Right.
And if you're applying this bill prospectively, not retroactively, you don't need a finding section.
Okay.
Okay. However, just with the discussion that we all had, this is what I took an attempt to draft. I just want to again emphasize this is you all as the legislative body making a statement that these findings are true. So you need to read them and be comfortable with them if you're going to keep them. But again, based on my understanding of this issue and the conversation, this is what I drafted. After recent, I'm just going to read it. After recent catastrophic floods across the state of Vermont calendar year 2023, the General Assembly enacted certain disclosure requirements on sellers of real property to notify buyers whether the real property was located in a FEMA map special or moderate flood hazard area. For portions of the state, no FEMA published flood insurance rate map exists, and for portions of the state, the published flood insurance rate map is not digitized, leaving certain sellers of real property at significant risk of failing to comply with the disclosure requirements. A buyer is equally capable of identifying whether the real property is within a FEMA map special or moderate flood hazard area. I'll pause there because I don't know whether that is a fair statement to make or not. I drafted it, but you all need to make sure that that's what you would want it to say.
It's funny, I actually felt like 2 was the one that we would take out.
Either,
Yeah,
and so then 4, requiring the seller to provide the buyer with a copy of the official flood insurance rate map, as opposed to requiring the seller to make a determination of whether the property is within a flood insurance rate map, is equally as effective at putting the buyer on notice regarding the flood risk associated with the purchase of the real property. I'm also just highlighting my somewhat concern with that statement. I don't know whether that's a fair statement to make or not. I've heard the statement made, a buyer can go out and do the, similar or equal research. So one could argue that it is, if you're just wanting the buyer to be on notice, it's equally as effective to simply give them the map as opposed to tell them where the property is. Some may disagree with that comment. And there are certain warranties that sellers are required to make to buyers, and so buyers aren't going to know whether the property flooded itself, for example, because they've never lived on it. So that's why the seller has to notify a buyer in that instance. So I'm highlighting those last 2 findings there because they kind of make more than just a factual statement. And again, you all need to make sure that that's reflective of what you want.
so,
Right, and so Randy, you're the one who asked, and I thought we'd ask for intent,
that's
not findings. So, and there's a difference, I think.
I think
So-
you leave
so-
4
so-
and just make it intent.
So, that was my understanding, is that we were doing intent, not findings. Randy,
I think that's correct.
May I ask Cameron what the difference in his mind is between intent and findings?
In this instance, legally, nothing.
oh,
Just because, again, the key I was commenting on was if you're applying it retroactively, if you're enacting legislation that is going to invite some sort of challenge, some sort of court interpretation issue, sometimes it's important for you all to clarify specific things, your intent, findings that you're making, etc., because you're signaling to the court. If the court's going to look at it and say, you're doing something, you need a strong public policy justification as to why you're doing it, you putting it in writing and saying, here's the public policy thing that we're doing, gives the court clear understanding as opposed to trying to interpret what you're doing. But in this instance, if you're just applying this retro or prospectively, there's nothing a court is going to look at this. So it doesn't have any legal effect whatsoever.
okay, Keisha, and then I think we need to have the conversation about, are we doing it retroactively or prospectively? Because I think we should probably be doing it prospectively, but
I think we should do it prospectively, but there's been like a long lost conversation about the art of findings and intent. And when you had someone like Senator Sears say, I don't want us to get lost and argue about the findings, the really critical piece that I think many of us came to, and I'll just say how I treat findings, is that they should be findings of fact.
Right.
And if you cannot treat them like a finding of fact, you're not citing a statistic that has a verified source, you're not just creating a record of the factual case you've made for a bill. They're not good findings, and they should not be treated as findings.
I agree. Findings of fact, and that's often what lead into a bill on all sorts of subjects.
Right, social media use is up
I think
25%.
the thing though, that one of the things that I was trying to have done.
Well,
here-
wait, I don't think Keisha was finished. Did
I'm
you?
sorry.
Oh, I think it would lead right to Randy's point that I think 4 is very artfully worded and could be changed into an intent statement. That it is our intent that we kind of follow existing real estate practice that requires sellers to provide disclosures, not interpret those disclosures for the buyer.
And I think one of the things that I was trying to point out is that requiring the buyer to provide this information does not mean that the information is accurate.
Right.
Because it's not in many cases. And one of the findings is that the production of these forms, maps, documents doesn't mean you've answered the question or you're able to answer the question.
Correct, because as we have come to appreciate, water moves and all these things change with every major event, like Irene. So many things changed after Irene.
It's almost a warning.
Yeah, and and with 23 and 24, I mean, different areas. So I think that's right. So I would be interested, I think that we want to look at a shorter intent section that is really focused around real estate, not the history of our flooding. But
Warning, man.
I think that,
Wrong information ahead.
so 2 decision points I think we have. One is, I think, we have prospective or retrospective, that's one decision point, and the other is a very shortened intent section, just an intent paragraph. What?
Depending on your first decision will lead me to a feedback on the second decision. So yes.
So, how are people feeling? And Peter, you haven't weighed in. You want to just quickly weigh in before we have those conversations? Are you okay with the language thus far, other than the findings in the intent bit?
Peter Tucker for the Vermont Association of Realtors. Yeah, the content of the bill that is being changed, removing the FEMA map questions, all of that is fine. If October 1st is a better date, because of fiscal years, things of that nature, also fine, moving it out to that point. And then regarding the findings or the intent section, yeah, I had envisioned something that was fairly straightforward. Just saying that, the challenge that sellers have faced is that the maps are difficult to interpret. And the necessity to provide, a link to the maps or a map for the buyer to make their own, kind of inspection of the property.
Oh, you had requested September 1st.
I did, yes. Mm-hmm.
Do you want to change it to, given you're the one who was concerned about the time frame, is September 1st what you prefer?
Either date works. I guess, I'm concerned about the extended exposure, of another month. I don't think it's going to be dramatic, but, trying to tidy this thing up. And I maybe a question to council, why October 1st? I wasn't clear on that.
Okay, let's just do September 1st. Thomas, what are your thoughts?
Denver.
So thoughts on next decision point, prospective or retrospective? Thoughts, committee. Peter, do you want to weigh in on that? Do you have thoughts?
I think that having a finding that, or an intent section that says, once the previous language was put into action, we found the difficulty, the difficulty of the quality of FEMA maps was exposed. I'm not sure how you exactly explain that, but that's really the only thing that I think is important is that, we tried this, it didn't work, and this is the change that makes things better for the situation.
Well, yeah, I'm not sure we can say that in statute, but we can certainly have an intent section about going forward.
Well, that's the warning that I mentioned in terms of being in the intent section. That's the purpose of it, is to alert people that we do not have confidence.
Right, and that I think is.
And that was designed, at least based on what I heard, designed to at least be a signal to the courts in terms of the reliance they place on any litigation that comes as a result.
Okay.
Does that make sense?
So I think what Cameron is going to say, if it's prospective, then your audience is not the court. I think the question in my mind is, are we trying to tell the House why we took a red pen to their work over the last 2 years? Because if we are, then I think what's important to me is to communicate to the House here or in person that we would be opening up buyers and sellers to a subjective transaction in the purchase and sales process, and that is not something we should do.
I'm going to invoke my inner Jane Kitchell. She never liked findings, so she'd always scratch them all. So similar to Senator Sears, I don't see the need for them, but I'm also.
So I think one short paragraph on intent would not be a bad thing. And I think that would be helpful. And I think you're clearer on what it might read like.
Not really. Because here's the thing. Here's where, if you're going that road, I would almost invite one of you all to draft it first, because Yes, sir. Yes, sir. We're making this change, and what I'm hearing is you're wanting to signal to people why you're making the change. We're making the change, and as Peter mentioned, he used the word found in what his description of your intent could be from his perspective. We found that the maps are hard to read. Okay, that's not intent.
Right.
Right? That's more of a factual statement. And so.
But is there a kernel of fact we can pull out of that isn't just like, we found this, but like,
You could say.
there's like a fact that says these are not accurate?
Where my thought went was you could say the purpose of us changing this, enacting the statute is because we found that, these maps are hard to read, et cetera, et cetera. But then and again, it just brings me back to what is the reason you're putting a purpose section in?
Well,
It doesn't, yeah.
so,
If I
David
can.
speaking.
No, Dave,
So I would agree, eliminating the finding section is
Fine.
important, it's fine. I do think that, page 2, paragraph 4, right at the top, that is a great basis for an intent section. And frankly, I think that line 4 and 5, that the intent is putting the buyer on notice regarding flood risks associated with purchase of real estate property, period. That's what this is all about.
Mhm.
That's the intent. Okay, we're not trying to solve anything. We're not making a judgment on FEMA.
yeah,
It's
we're
all
not
about-
saying the FEMA maps are terrible or
Just
not up to
elevating-
date. We're just saying, this is putting the buyer on notice.
Just, I
Right.
don't think it needs to be any more complicated.
Like that.
Sure. If we were at all, this is why I don't want to go in the direction of findings, is because I think it would require that Cameron do extra sleuthing to find a fact-based case to put together, which a quick Google search has lots of websites that say FEMA maps are inaccurate and will definitely be inaccurate going forward because it cuts to their budget. But unless we were to try and build a fact-based case around that, I think we should just let it go. And I hope we can bring some of those articles to House General and be like, here, we're not doing that.
If you want to go that succinct, I could put something that says it's the General Assembly's intent
Yes.
to ensure that a buyer is on notice regarding flood risks associated with the purchase of real property, and you can leave it at that. If you
That's-
want
Well,
something
doesn't
that
point to
succinct.
the fact that what we've asked them to do should be relied upon. And we are expressing the concern that it can't be relied upon
Well,
So again,
it all
it's
needs to be
in all
weighed.
cases.
It's, there are a lot of variables and you need to weigh them all and you need to understand that they're imperfect. But I think that very short intent would be fine by me. But I had almost exactly the same language you did.
But do we also want to say something about limiting like undue exposure for the seller?
Peter?
Yeah, I think that, the changes that Ledge Council has made to the way the map questions are, that we're going to deliver map or link, electronic link. Really, that's the important concept here. And, I feel good if I was representing a buyer that I would get information that I needed to make an informed decision. As far as findings, certainly I think regardless of whether there's, a small amount or a large amount of intent or findings in this bill, should a seller be exposed to liability, the fact that the change has been made really supports the fact that the seller's, inability to interpret a map, it was there previously, and get that language into place and we go forward. And quite honestly, I am not aware of any sellers, or any buyers seeking damages at this point in time. So, while I appreciate the efforts of the committee to, to clarify, our inability to use FEMA maps effectively, at the end of the day, I think the other portion of the language is way more important.
Right. So, committee with David?
Just one other recommended change, and I just heard Peter say it.
Yeah.
Page 2, line 15, where it says a physical or electronic copy. I think it should be a physical or electronic link.
Well, a
Electronic
physical link,
copy.
you could have a physical copy and
Copy
an
and
electronic link.
link.
Right, that's what he said.
Oh, okay, sorry.
You could,
That's
could
what
you
I'm
just
trying
say
to say.
physical or electronic access?
But you could have a physical or electronic copy. Sorry, just trying to be funny.
Yeah, I would, no, I would probably make it three things.
Yeah.
A physical, I'm handing you one.
A
An
physical copy,
electronic,
you
I've
say?
attached it to an email, or the link. I
Yeah.
appreciate the clarifications. I think it's probably important.
Yeah.
Yep.
Great, thank you, David. So what are the,
Just trying to be funny.
okay, great,
Yeah, that's certainly right.
terrific. So we have a change in, we're cutting out all the findings on the first page, calling it intent. Having a much foreshortened intent section, which is one sentence long. Changing the language in 3. And changing the date. Those 3 changes, yes? Oh, additionally?
Yeah, page 3, line 1, that the seller maintains the flood insurance.
Oh.
I thought we had
Yeah.
that conversation ad nauseum.
I have that question, a question mark by that too, because I thought we had wanted to, their requirement to carry flood insurance is different about whether they maintain it or not. And you had
Yes.
thoughts on that.
I did. So I went back and forth a little bit. The Senate, as I mentioned last year, and the Senate's proposed language to this was if, notice the, notification of the buyer if federal law requires them to maintain flood insurance. And in my head, as I was getting ready to insert that in, my thought was if you wanted to be more expansive, then I would leave it as it is, i.e., I may maintain flood insurance and not be required to do so. And if you want the seller to notify the buyer of that fact, you can absolutely change it. Just as I was going back and forth in my head, I felt that it may be best to leave it as it is.
Well, it's the other way around. If they're required, but they don't maintain it, that doesn't solve anybody's risk awareness issue. It's about being required,
Yes,
period. Who cares if you maintain it or not?
yes, because I know people who are in the flood zone who have chosen not, and I don't know who enforces their getting flood insurance. Peter, you're gonna weigh in. Peter?
Well, and I guess more of a question is that, if somebody doesn't have a mortgage on the property, are they required to maintain flood insurance? And I think the answer to that should be no.
No, they don't.
They're
They don't.
able to attain flood insurance, but they're not required to maintain it.
And so could we do both? Can we have and?
Yes.
Can we have required and or maintains it? So that we cover both bases, because I with David had the same question mark on that. Because, and they're maintaining it even if they aren't required to, also tells you a lot about whether a property has flooded.
Yes, it's an easy,
Is that easy?
it's easy fix.
So, given our time frame, I'm just curious, Cam, what magic you could work between now and noon? If we came back at 5 of 12?
I should be able to have something to you by 5 of 12, yes.
That gives you 15 whole
It
minutes.
might be a vote pending edits, but we do that, so.
Are we okay?
You just do
Coming
it
back?
tomorrow
Okay.
morning too.
So, what?
You could just do it tomorrow morning, first thing.
Or we could do
Go
it
up.
tomorrow morning first thing.
I would put it to Cam. You wanna do it tomorrow morning? You wanna do it in 15 minutes?
Either we are easy either way.
Well, tomorrow morning isn't gonna put any immediate pressure on me in the next 15 minutes, so that's easier.
Yeah.
But if you want it done, I can do it in 15 minutes.
Where else? What's the path of this? This also has to go.
I presume I don't believe it needs to go anywhere else unless you have another committee of another committee in your body who
So
feels that
given-
they want it, but in the House, it did not go to any of the committees.
Right, it just went straight to
It
the floor.
didn't have an appropriation.
Okay, great. So just moving things along, if we're possible to do in 15 minutes, I would suggest we get this baby off our plate.
I'm not gonna move. I'm gonna sit right here.
Okay, you're gonna